Montana's story begins more than a century ago when, even before statehood, the treasure state attracted outside interests to exploit the vast natural resource wealth that Montana has to offer and still has to offer. Unfortunately, that exploitation ran to our democracy as well. And so the people of Montana saw this. They saw it as corruption. They called it as they saw it. And rather than looking to far-off courts or congressmen, they said enough is enough. And a supermajority of miners and farmers and businessmen, a Republican newspaperman from the small town of Fort Benton, who also happens to be my great-great-grandfather, got together and said, now, wait a second. As Brad said, this is popular sovereignty here. You, our politicians in our corrupted capital, do not govern us. You, our courts sworn to uphold our Constitution, do not govern us. You, copper kings in your faraway mansions, certainly do not govern us. We govern us. And so they did. They took the initiative power upon themselves, and shortly thereafter, 100 years ago, in 1912, passed the Corrupt Practices Act. And that corrupt practice that they targeted was corporate contributions or payment in support or in opposition of political candidates or nominees. They called it as they saw it, corruption. Nowadays, that law, which some refer to as a ban on corporate speech, I'm not sure anyone in Montana for the past century would say that corporate or any other interests have been silenced. It requires them to fill out a two-page form, file it, and participate in an American tradition of political accountability to real people. You put your name where your money is, you spend your own, not other people's money, on campaigns, and you stand up and be heard. Ironically, a group calling itself American Tradition Partnership from these parts, not from Montana, although we don't know much more about them than a post office box, in the wake of Citizens United, for the first time in this century, a long history, sued to asked courts to throw out our Corrupt Practices Act. Our Montana Supreme Court, to its credit, which like most courts in this country are elected and know something about politics, upheld it and held that Montana has a compelling interest in preserving the integrity of its democracy. Unfortunately, the U.S. Supreme Court, in reviewing American Tradition Partnership's petition, stayed the Montana Supreme Court's decision and left us for the first time in a century without the protection of the Corrupt Practices Act. They conferenced on the petitioner's request for U.S. Supreme Court review of this case in Montana's century-old law on Thursday, and we may hear what happens as soon as Monday. And I guess I'd want to close by suggesting that I hope that the lesson that we're able to take away from this is not the 2012 lesson of abstract legalities or what happens in the halls of the U.S. Supreme Court or any other court, but that the lesson is rather not from 2012, but from 1912, when a group of people, a supermajority across partisan lines, saw corruption, called it as they saw it, and took an important step towards reclaiming their democracy.